Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Heldt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Welcome to the podcast today, and today we have Ruce, who is the founding member of Stoneark Law Office. How you doing today, Phil?
I'm doing great, Gary. Thank you for having me on.
Good. So what was it that made you want to pursue a career as a state attorney?
That's you caught me off guard. That's a good one. I'll try to make this a short version. I benefited when I was growing up from a fractional share of this thing called an irrevocable life insurance trust. The result is it paid for some of my law school tuition, and it was fascinating to me that 2 generations ago, somebody had created this thing to benefit somebody who that person didn't even know, that my family in turn has received from that. Just what an interesting thing you can do to control a legacy after you're gone and benefit the loved ones of your loved ones. And that kind of what triggered my interest in trusts and estates. And after a 5-year, I don't know if I want to call it a career, but a 5-year job as a financial advisor, I went back to law school in 2005.
Great. And you've written a book, Trustee University, the Guidebook to the Best Practices for Family Trust. Tell us a little bit about that.
When I was my first 6 years out of law school, I worked as a trust officer. And what that means is I worked for a large bank, which shall not be named, as well as a smaller bank, kind of in the metro here where I live and work. And I took these estate plans and I had to make them work after someone had passed away. So somebody had created a trust for kids or a spouse or for a charity or for estate tax purposes. And we'd take that document that was drafted by another lawyer and we'd actually do what it told us to do. We worked with a lot of family trustees who were co-trustees along with us. So we were appointed as being the manager of the trust. That's basically what a trustee is. And then there was a family member who was working on the trust with us. And they very rarely had any clue what they were doing. And that is not their fault. It's just they're in a role and accepted the role because they're a loved family member or a responsible person. And here they are doing a job that they just didn't realize was kind of a job. And it seemed like it would be helpful if I created a guide for that. And honestly, I started it out as more like a 30-page pamphlet. And it just, there was so much I wanted to talk about that it just turned into this like hundreds of page book. But it's out there on Amazon.
So, I've read some of the books so far, and I find it, really fascinating, because we do help people with the tax returns and things like that afterwards, and find out many times that, the individuals do make mistakes, kind of as they're going, or just the assumptions that people make aren't always correct. Lots of times I run into individuals that think that, their financial power of attorney that they have for their mom also takes care of all of their health directives. Can you talk a little bit, on, the different types of, power of attorneys that there are?
Right. And that's actually another really common question that we get is someone dies, someone will call us and ask if they can be named as power of attorney so they can access all the financial accounts and get the estate distributed. And a power of attorney, as you know, is something that only lasts during life. It is a lifetime document. And the first one to talk about, I think that people think of the most often, and I think what you're referencing here is a financial power of attorney. And there's a couple types. I'm going to touch on the main 2 here really quickly. I know there's other questions today. I can talk myself into corners because I get very excited. So I'll talk about these 2 first. So a financial power of attorney comes in 2 basic flavors. The first one is common law power of attorney. And this is that thing where you can write whatever you want. I want this person to have access to these bank accounts. I want them to have access to these business interests, this house if they need to sell it. And these things are great if we're doing like a business transaction together, because we can be very specific, and then we give it to the bank or financial company, they send it to their legal department, and they give us a yes or no on whether or not they like that document. We don't have to accept it, it's an authorization. That's great for business. That's not great for incapacity planning, which is oftentimes why we're doing a power of attorney. Incapacity planning is when you can't make decisions for yourself. Who can make decisions for you? Well, obviously, we've created this common law thing with all the specifics on it. The bank doesn't like it. We can't get another signature on that. You're incapacitated. So usually, not every state has this. Many states do, though. There's another one called a statutory power of attorney, and that comes right out of your state's law. It's language that's in the statute. You can't do any custom drafting for this, so there's not a lot of customization, but you can name the person. It's called your attorney in fact. The person, that's the real name for a power of attorney, is your attorney in fact, who can make financial decisions for you, access bank accounts, access business transactions, insurance transactions, investments, etc. Usually a checklist of what powers they can do. You sign it, and now they have access to your finances. The nice thing about this is this format in your respective state is probably the format that everybody uses. So it's never going to get to the bank's legal department or whatever the institution may be. They're just going to accept it. So that's a financial power of attorney. That's kind of a high level. And there's even more. There's durable. Durable means it continues to be effective after you're incapacitated. That's what durable means. Usually you need a common law. No, sorry, that usually the statutories are durable. Another one is a springing, which is it's not effective at all until you are incapacitated. So it's not good at all. And then once I'm incapacitated, it's out, and suddenly now somebody has access to my finances. That's going to be a common law. Almost certainly there are problems. How does that business know that I'm incapacitated? You know, some other questions there. But broadly speaking, that's your financial power of attorney. The next thing is your healthcare directive, also called a healthcare power of attorney, also called a living will. Some states divide these into numerous documents. Some states combine them into one document. My state does combine this into one document. The primary thing you really need is to have an agent, and that is your person who can make health care decisions for you. This has nothing to do with the money. In fact, the person making healthcare decisions for you may not have access to paying the hospital billing. That's possible. They're two separate things. One's financial, one is having to do with the human being. So if I'm incapacitated and I'm in a hospital bed, I need someone who can talk to my doctors. I need someone who can make sure I'm living in a safe place, getting the care that I need. And when there has to be a decision, sometimes a very difficult decision, I need that trusted person in place who can do that for me. So the first part, technically the power of attorney, healthcare power of attorney section, is where you're just saying who's in charge. Some states separate this next part out again, some combine it into one document, but the next part is more of your directive. So this is instructions set out on what it is that you want to happen. So typically we're going to say this person has the ability to talk to my healthcare professionals. They have the ability to consent to treatment, withhold treatment, access my medical information. Oftentimes we need a HIPAA release. That is potentially document number 3. Again, some states, all one big document, so that there aren't any privacy issues with theirs. So we need to authorize them to act on our behalf and access our information. You can also have in here, a preferred doctor, a preferred hospital, anything like that. One of the main things we want to make sure we touch on, how people think about end-of-life care. And oftentimes, I think when clients come in, the term they hear is pull the plug. And I think that's a good way to think about it, but it may not be pulling the plug. We want to know there's no reasonable chance of recovery. If I'm in a permanent coma, I'm incapacitated, I have advanced dementia. Dementia has multiple stages, and I'm at the point where I'm not really there anymore. Do they have to keep, and that's not euthanasia, but do they have to keep me on the ventilator, for example?
Right.
Can we? So that's all relevant things. You can talk about other things that are important to you. You can talk about, I want clergy members present. You can talk about what happens. Do I want to be cremated, buried? Is there a ceremony or a wake of some sort that's important to me? Do I want last rites or some other faith-based attention? And it's a really useful document. It's a very important one. I think anybody over age 18 really should have a healthcare directive for power of attorney. It's a little softer. It doesn't really go well with like a checklist. So it does require a little bit of thought when you're doing this, whether you're doing it on your own or whether you're doing it with an attorney. There's some questions about that with your family. Always just, the most important thing, naming the right person.
Right.
Almost more important than getting granular on the requirements and the things that you.
So, you know, obviously this isn't, you know, super simple. And I can see where people, you know, could certainly make mistakes in understanding all of these different, you know, powers of attorneys and stuff like that. Besides having the correct power of attorneys and so forth, what are some of the questions you really wish that the clients would ask you that they don't ask you when they come in and sit down with you?
I've fortunately become pretty good at anticipating what people don't know that they don't know, and that comes with repetition, I think. But there's a couple really big misconceptions that you'll hear. One of them is the idea that if you have a will document, that your estate will not go through the court system, and that's not true at all. That's actually what a will does. If it controls court. A will is a court document. I could underline that 3 times. A will is a court document. If you don't have any documents at all, and you go and something happens, you pass away, we use your state's backup rules. They're called the intestacy statutes. They are all built out for you. There's a default estate plan that everybody has. Doesn't matter who you are, what you have, everybody has the same plan. Generally speaking, we want to at least overwrite that. And that is what a will does, is it takes the state's laws, state's rules, overwrites them with your rules, and by virtue of that, you get a big say on where probate goes, who's in charge, who's the backup, that's your executor or your personal representative. What happens if that person can't act? Where does the money go? Who gets it? If something has happened to that person, where does it go? We can hold money back from minors until they're 30 or something, whatever you want. Decide in what order bills get paid. It's very, and we can, if we have an estate tax issue, we can manipulate that in some ways with the will. Very, very good tool, but I will underline this again. It is a court document. So if I die, we take my will and we submit it to the court system, and then we have probate. It has 3 big drawbacks. Every state's a little different. It can be very expensive. There's certain states like California, New York, and Florida where tens of thousands of dollars to get a family through probate, in part because the fees for those are set by statute, they're set by laws, so it's not really an hourly rate. It's just they get this amount. Some states are not like that. My state where I work is not like that. It's just hourly. Something less than 10 grand to get through probate, hopefully closer to 5,000 depending on the state. But they're very, very, it's going to cost money. Where you live is going to be a big indicator of that. And your will is going to require those fees. Another thing that can be frustrating for people is that it takes a long time, potentially. Oftentimes, in every state, every county within your state is different, but you oftentimes have to get on the court calendar, and the court calendar can be 6 months out. So meanwhile, the family would like to sell the family home, but they can't do that until they get a piece of paper from the court saying that they're appointed and they have authority to sell the house. So meanwhile, the family is making house payments, property taxes, whatever they're doing, just waiting. And then lastly, it is public. It's the court system. Again, there's a variation by state, but you know, I have 2 very little kids at home, and there could be concern with people knowing that they're getting money. If we're using the state's intestacy rules, the default rules, then that's public, who gets what. And then if we're using a will document, sometimes it can be challenging to get a hold of a will, but oftentimes all you got to do is go to the courthouse, pay a $20 fee, and you can see somebody's will, and then they know that. Those are the concerns with probate. I wish that people knew coming in that that's what it was, and there's a lot of myths about it. Sometimes they think it's way worse than it is. Sometimes it's going to be fine, but there's a lack of familiarity with what mechanically actually happens when this happens, and when there's a lack of that familiarity, there can be a lack of understanding what they're asking their fiduciary, their executor, their trustee to do. So just, you know, I cover that in front of every meeting, at the beginning of every meeting, to kind of get people on board with that. But That's one of the things, just a big misconception about what probate is and how to avoid it. Do you want to avoid it? Is it worth it to avoid it? You can avoid probate. It requires some advanced planning. But that's probably the biggest thing that I see is just a misunderstanding of the process.
Right. And then, you bring up the planning piece, and that's something that I am constantly preaching to, all of my clients. It's like, look, we can do much better to help, lower your taxes and do things like that if we plan. So the big thing is talk with someone, talk with a professional before you do something. And, I know that, with your book, it's, a guidebook, and it's there to help people and stuff like that, but it's not, in my opinion, it's not meant to replace you as a professional. So tell me, instead of, hey, I'm just going to read your book and I'm going to know how to do everything, why is it that someone needs to come to a professional like you to get help with their estate?
One of the things that I hope the book would accomplish, and this can be accomplished with a conversation with a qualified attorney as well, is what is entailed with planning. It's not going to give you every single aspect of how to do it because everything is just so different. Every state has different rules, and every county within every state potentially has different rules. When it comes to probate, for example, there are very specific legal decisions that have to be made. Every state has a different process, but where I am, for example, there's 3 levels of probate. There's a very informal one, which can be very fast and cheap, but you miss out on some protections and some other guidance from that. There is one that's more formal, and in that type of probate, you get more protections. It's definitely going to be more expensive. And then there's a really closely supervised type of probate, which is ideal if there's any sort of disputes. Which one of these should you be in? And that can be really challenging for folks. And then once they do it, the registrar or the judge, depending on where you are, might not like the documents you fill out. And you're going to be doing that a few times, and you might miss some information. I have had people come in with a probate they did on their own. And this might seem like a minor thing, but when you name the person who has passed away, so my name is Philip John Ruce. If something happens to me, Philip John Ruce is what has to be specifically on every single document. If you do Philip J. Ruce or just Philip Ruce on one, now you're walking into a point where if you have to do a real estate deed, you got AKAs, you got to do all this other stuff, and it gets on, and that's just one little thing, one little administrative thing. But you get more than a couple of those, and now we start to get a really messed up probate. So you have to be very careful about that. And the same aspect can happen with administration of trust, revocable trust when we're skipping probate. The fees for those are almost universally less to administer a revocable trust, if there's any fees at all. Oftentimes the family member can just kind of do it, or they'll try to sell the house, realize it's in a trust. The title company will say, oh, you need to do this, and they do it, and they don't need an attorney. But I think, and that's if it's a basic estate. There's going to be tax issues. There's going to be distributions from retirement funds that are going to be taxable. There's going to be capital gains to the extent that a joint gift maybe was made in part during life. Like there's this rule where your capital gains really go away when you die, which is great. Because if I have a building and it's appreciated and then I die, my heirs are probably not going to pay capital gains on that to the extent that there were gains during my life. It's called a step up in basis, as you know, I know, Gary. But what you'll find out sometimes is somebody added a joint owner about halfway through. And now that joint owner, who's still alive, doesn't get that reset. And then when they sell it, they don't always know that that person's got gains. So you run into some of these, it seems obscure, but they're common, and they're not necessarily rich people problems. Some of these things, sometimes it's just stock. They put their daughter on their brokerage account during their life. Having a professional, I think, to, if nothing else, issue spot, I think is half of it. In fact, even when we're just doing estate planning meetings, not even administration after death, just having me there, they might come in thinking they want to give everything to their spouse and their kids, and then we do end up giving it to the spouse and the kids, except there's all these other contingencies that we add in there that they didn't even think of. And I think that you probably experience the same thing. People come in with just thinking they've got ordinary income on their income tax or something, and it turns out there's all these other things that they just didn't even know they had to think of.
Right. Yeah, I think that, especially with, with COVID-19 going on and some of the changes that have happened in the past year with the tax law changes, I think it's really going to change things. Looking at ways to protect our assets and things like that are really important. And from a in the state standpoint, can you talk a little bit about hey, my mom is getting up there in age, she's going to be going probably into a long-term care facility and so forth. How can we protect her assets so they're not all used up just to pay for the facility?
That's a great question, and that is one we get quite a bit. And that is an everyday person question. That again is not, I think there's a misconception sometimes that estate planning and tax planning is something that wealthy people need. And these types of questions are things that affect every family. Every family is concerned about, if I have $200,000 to my name and I'm going to have $10,000 a month in advanced memory care, that's not going to last very long. Can I still leave my kids something? This is, again, a very state-specific question, so it depends where you are. My state does not give this option, but the state where you live, let me back up. Here is something you can always do. What we're talking about here is how do we get government benefits to pay for our long-term care? And what I mean by that, this is not Medicare. This is not something we've been paying in for our life. This is something where the general tax fund is assisting us with care. This is part of the safety net. We are all responsible for our own long-term care costs. We have to pay it. It's just like if you chose not to have auto insurance and then you get in an accident, you've self-insured. You're gonna have to pay for whatever happens there. So you are responsible for your own long-term care. There's a couple ways to address this. There are various insurance products. Long-term care insurance is certainly one of them. There's also a lot of regular life insurance policies that will have a rider that'll give you a few $100,000 to cover your long-term care for you and a spouse. Those are actually just generally, however administratively challenging some people feel long-term care insurance may be sometimes, some people just love it. There's a big benefit there. I'll mention a couple of things. I'm not licensed to sell insurance, and I'm not selling insurance. This is not something that I would benefit from anybody who's listening to this doing. It's just a general opinion. One of the challenges with long-term care insurance is not knowing whether I'll need it, or the converse side of that, how much of it I'm going to need. I might not need long-term care at all. I might need long-term care for 10 years. In part, I think that's a wonderful risk to shift onto an insurance company. It can be expensive to do that, but it's such an unknown. If my house burns down, I know how much I'm going to have to pay if I don't have insurance. That's a set dollar amount, and I can name that risk. I know what my risk is. If I need long-term care, I have no idea. It might be a year, it might be 10 years. There's no way. So when it comes to long-term care, we are responsible for our own bill. So insurance is one way to do that. If you can get ahead of it, if you can get insurance prior to needing it, that's another problem. Great. There are insurance products I'll mention that it costs a little more upfront, but you can get a refund of your premium if you end up not using it. Called a rider. You won't earn any money on that, but let's say I give a company, I'm going to use a round number. I give a company 50 grand, and they say, okay, you got a couple $100,000 in long-term care if you need it, and if you die and don't use it, you get $300,000 in life insurance paid to your family, and next year we'll just give you back your 50 grand at 0 interest. There are products like that, so they can eliminate some of that. You do got to qualify for them. You need to do it before you're sick, and that can be hard. Okay, so insurance is one way to pay this bill. Another way to pay this bill is you just pay it. You have your own money, and you're responsible for it. So if you don't have insurance, you're going to have to start kicking out money, or your family's going to have to start kicking out money until you're broke. And that's what our next stage is. The safety net, the Medicaid, The long-term care government provided benefit is for people who don't have any money. So if you have money, you have to pay for your own care or get insurance. The taxpayer is not going to pay this benefit for people who are able to pay their own benefit. That's what it comes down to. And sometimes the way this is phrased is, how do I keep the nursing care facility, or how do I keep the government from taking all of my money? And really, I mean, you're getting a service from a private entity. You're getting care for long-term care, and they are getting compensated for it. You're getting something for it at a steep cost, of course. Once you're broke, that is when this government benefit can kick in. So one of the questions becomes, can I make myself appear broke faster? And there's a couple, the answer is yes. It's not always pleasant. There's not a lot of ways to keep your money and make it look like you don't have money. If you have access to your money, if you have free access to your money, it's yours. And the taxpayer is going to know that. The state government is going to know that. There's a couple strategies you can use. Every state's a little bit different. In my state, anything that I gift away 5 years before needing long-term care benefits from the state is not counted. It's not money that has to get clawed back. So let's say I have $1 million. I give $500,000 to my children now. I'm perfectly healthy, living off my 500 grand and my Social Security and maybe my pension or whatever it is. And then at year 7, year 8, whatever, well past that 5-year mark, now I need long-term. I've spent it all. I need long-term care benefits. That's great. I've done it. I made myself broke faster, and I was able to get some money to the kids. So lifetime gifting is one way to do that. That's tricky in retirement because you need the money. So how do you time that? Sometimes people have so much money in retirement that there's just no point. I mean, they can give money away, but they're just never going to spend it down to zero. So it's just all you're doing is getting rid of your assets. So that's one way, is lifetime gifting. Sometimes in some states, not mine, you can create a trust, and the trust can severely limit your access to the money. Like, you might take the principal, I'm going to use a round number, I take $1 million and I put it in this trust. I have given up that money. That is very important. I haven't sort of given it up, and I can still take it out if I change my mind. This is a permanent thing. It's gone. But the trust might pay income to me. You can also do this with certain annuities. You can give the annuity amount to an insurance company, and they convert this into income. Income will not disqualify you from care. It'll be used towards your care, but you've gotten rid of the asset. And because you've gotten rid of the asset, whether in this annuity or in this trust, you can keep the income stream, but you're officially broke. You're out of money. So you qualify faster, and then that trust at death would pay to your kids, of course. So you're giving them kind of a future gift, but you've eliminated your access to it to the point where you just don't, it's not yours anymore. And because of that, these state benefits would see you as being broke. So it's one of those things that's really tough to plan for. You've heard about people you'll hear your neighbor say, oh, so-and-so, they took their house for long-term care. Not usually the case. Usually you can keep your house. If you have a spouse who is healthy, they get to keep the house. They get to keep an additional sum. They don't have to be totally broke. There may be a lien placed against the house that is collected once your spouse sells it or dies years in the future. But the taxpayer really wants their money back for this benefit. So that's the thing. And to the extent that you're comfortable doing this, that is definitely something to talk to a professional about. I would not try to.
Yes. Yeah, I definitely, and again, you know, going back to this keeps going back to planning. Make sure you do the planning. And then like you said, this isn't just a wealthy person's issue. This is, you know, everyday person. I mean, you know, you have a home and a couple kids and a job, you know, type thing. You know, it's important to do this planning that needs to be done. You know, what are, you know, some of the big challenges that you're facing right now?
Well, I mean, when it comes to what's going on in our country here with illness and some fear,
Yes.
one thing that's been a little strange. I don't know where everybody who's listening to this may be, but I'm in a northern state And traditionally, this northern state almost completely shuts down for the summer because everybody goes on trips, the kids are out of school for 3 short months, and it's beautiful outside, and it's going to be a very cold winter, so everybody just gets out. And that didn't happen this year. The kids have been out since April anyway. No one is doing any big traveling. They might be going to some cabins here and there, but they're not taking huge summer trips. So we've had it's been very consistent. Usually our business gets very slow with estate planning. People don't want to think about the serious stuff until the kids are back in school, and that's not been the case around this year. We've had a fairly consistent level of planning. One of the biggest things that is a concern for people is going back to that healthcare directive, just making sure that there's somebody there who can make healthcare decisions for you if you become incapacitated. Whether you actually get it in a way that's serious is less of the issue, I think, is the peace of mind of knowing that or any aspect of incapacity, you're covered. That's what we're looking for. One problem, of course, is many times the people who are the most susceptible to the coronavirus are the most vulnerable people. And strictly speaking, from a frustration as an estate planning attorney, I can do phone meetings and articulate what we need to articulate very well. I've got just practice. I can do that. People understand what I'm talking about. The elderly are less likely to understand Zoom. I think you can understand that. So it's probably going to be a phone call if they're not going to come in person. And we take precautions as much as we can when there is a vulnerable person coming in. I'd rather they did not. We wipe down everything. We obviously masks, obviously sanitizer, we clean our pens. But one of the things that's a little frustrating is the legal profession is always about 10 years behind the rest of the world. And wills and trusts still need an actual ink signature, and they still need an actual notary. And that requires at least one in-person meeting. And we're very respectful on how people do this, but it still has to happen. So that's been one of the new things. That was a non-issue before. People come in, you shake hands, and so well, you hug, and you just kind of get it done. So all that's changed. The method of planning has changed. It's not as in person. There's been some practical frustrations, and it's not frustrations with the world. It's just, this is the way it is now, and we just have to figure this out. And there's no ideal way. It's a little less personal. I think those are the big things that I've seen is just getting it done, and how do we help people who may be vulnerable to get it done in a way that's very safe. And we do our best that we're able to.
So, Phil, if somebody wants to, wants to talk to you and get you to help them, with their estate planning, or if they've already done it and they want somebody to look over it, how do they get in touch with you?
We are at online is always a very good way if they have access. www.stonearchlaw, STONEARCHLAW.com. If we can't help you in your state, we do have resources, so give us a call. You can also call us at 612-345-7496, 612-345-7496. I'm always happy to chat or provide a referral.
So, but if I'm going to reach out to you and stuff, I don't have to have everything already planned out and laid out or anything like that, do I?
Absolutely not. I thank you for that. Most people who come in, I think, just know they need to get something done. And most attorneys that do this will oftentimes have an initial phone call where they just ask a couple questions about you, just very broadly, kind of what are your priorities, and oftentimes they give you kind of a cost estimate right there, and it's just a free call. We certainly do that. If you decide to move forward with a planning meeting, there's oftentimes a questionnaire, and doing your best on that is really all that's required. It just helps you to think through some of your important people in your life. And to the extent you're able to do that, you come in and we'll guide you the rest of the way. Your attorney or whomever you choose should be able to guide you the rest of the way. You do not need to know anything going into this.
Okay. So for if the listeners want to get a hold of your book, Trustee University, the Guidebook to the Best Practices for Family Trustees, where can they find this?
That's Amazon's the best way. Look for Trustee University, or you can search for my name, Philip with one L, J, Ruce, and it'll come up. And it's my hope is it's a resource for those family fiduciaries who maybe didn't realize what they were getting into, and also don't realize when they need help. Sometimes that's the biggest question.
Great. So, Bruce, Phil, I really appreciate you joining us today. This is a lot of great information that you provided to us. And, so today our guest has been Phil Ruce with Stone Arch Law Office, and we appreciate your time.
Thank you so much, Gary. It's my pleasure.
This show has been produced by Market Domination, LLC. To discover how you can have your own show completely done for you and turn it into a real published book and become the authority in your marketplace, go to www.marketdominationllc.com/podcast offer.